much.
You're welcome.
Good morning, everyone. We're about to start the matter of State versus Bermudez. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I believe counsel have been here before during our virtual arguments. When a justice has a question, they will either raise their hand or the virtual hand. Once you see that, please stop your argument at that point and let me call on the justice to ask the question. With that, appellant, are you ready to proceed?
Yes, I am, Your Honor.
Okay, thank you very much. Please identify yourself for the record and let me know how much time you wish to reserve for rebuttal, if any.
Thank you. Good morning. My name is Pam Nagy, Assistant Public Defender, on behalf of Noel Bermudez. And with the court's permission, I'd like to reserve 5 minutes for rebuttal.
Thank you very much. Justice Dario will be our timekeeper. He will let you know when there's 5 minutes, 3 minutes, and end of your main argument.
Thank you. Mr. Bermudez was convicted in this case solely on the word of Damaris Algarin, who waited 12 years before going to the police with what she claimed she knew about the shooting. The appellate court was wrong to uphold the trial court's evidentiary rulings in this case that pertain to Algarin's testimony. And there are several reasons why. First, with regard to the evidence that Mr. Bermudez and his brothers were in a gang, the problem here is that there was not a proper balancing here by the trial court or the appellate court. You know, gangs have a stigma. You know, there's no question when people think of gangs, they think of a group of violent people who commit crimes, usually violent crimes, including murder. And yes.
Counsel, it seems you're conceding here that there is a balancing test, correct?
Of course, yes, there's always a balancing test.
And this individual claims that she was afraid of the defendant. And one of the reasons she was afraid of him was because of the gang affiliation. Is that correct?
That is correct.
Okay. So please explain to me in a way that I'll be able to understand how the balance here tips in favor of the defendant.
The balance is in favor of the defendant because this is highly inflammatory evidence, as all courts recognize, as well as the appellate court recognized it had the potential to inflame. There was unfair prejudice. And here there was ample evidence as to why she delayed. You know, that was the bulk of the state's case on direct examination. She testified she was afraid of Santiago. He beat her on a daily basis. He threatened to kill her. Once she learned about this, he threatened to kill the children. He threatened to kill her mother if she snitched.
But isn't that all grist for the mill? The jury can hear this and figure it all out?
Well, sure, the jury can hear all of that, but the jury, it was, as I said, it was the bulk of the state's case here. And as the state even said before the appellate court and before this court, the gang evidence was not a critical part of its case as far as why she delayed. It was primarily, and almost significantly, because of Santiago. And not only was there evidence about all his threats and his abuse, there was evidence that even when he was in prison, she testified she felt unsafe because he would do things. Tommy Bonillo, the third brother, also moved into her house uninvited when Mr. Bermudez and Santiago were in prison. So there was all of this evidence. And because there has to be a balancing test, courts around the nation recognize you should really be very cautious about admitting this type of stuff into evidence. And here, when you have all of this evidence already that came in about her reasons for delaying, and this was not a critical part of the state's case, and yet the potential to inflame the jurors is so high here. It was an improper balancing. The prejudicial effects here greatly outweighed the probative value. It was cumulative. There's no question it was cumulative here.
Okay.
And on top of that, I'm sorry?
If you finish answering my question, I see there are like 4 different justices who have questions. And so,
I'm so sorry. I didn't see the hands. I'm sorry.
It's not a problem at all. I just want to make sure that we do address all of their questions. Justice McDonald?
Thank you, Chief. Counsel, help me out with this. So this was a relevancy objection, and I guess I'm just trying to figure out how it was. I mean, at that point, this was on direct examination, right?
Correct.
So had anybody put into issue Algerin's credibility on direct examination? Had the state put her credibility into issue? I mean, I guess what I'm coming at is, if I could see if the defendant on cross-examination attacked her for the delay, then you would be attacking her credibility for the delay, and the state, in my view, would be free on redirect to bring up the gang affiliation to explain the delay. But in the case in chief, I'm trying to figure out how her credibility is in issue for purposes of a preemptive rehabilitation of her lack of reporting.
Well, it had not been brought out. I mean, this was something the state was anticipating because they knew it was a big problem with their case. And so it did come out on direct. Her credibility had not yet been challenged. So, that was part of the problem here. I mean, this was part of a motion in limine prior to trial.
No, and I get that. It seems to me that the defendant would have to make a choice going into cross-examination, knowing that this was where the state wanted to go, whether to attack her failure to report for 12 years and open that door. But I just don't know how. I'm struggling with how it is relevant in the state's case in chief. And I'm going to be asking Mr. Costello the same thing, so he has an opportunity to think of the answer right now. But from your perspective, why is it at that point proving the crime is the only relevant issue at stake, right?
Correct.
Okay, so I just want to be clear. There was nothing in advance where the defendant somehow tipped off that it was going to go after her for her lack of disclosure more promptly. Was there?
Not that I recall. I mean, there were, the other brothers had already been tried. There had been through the trial before, not with this attorney, and obviously not with Mr. Bermudez. So all I can say is my guess is they already knew how, the testimony was going to come out. That's really all I know.
Okay, thank you.
But, getting on, in addition to this, we have the evidence of the relocation. And I'm not saying there's cumulative error. Obviously, we don't have that here in Connecticut. But what the court also did, and what the appellate court sanctioned, despite finding that it was unnecessarily prejudicial, she's allowed to testify that as soon as she gave her statement to the police, she's relocated at state expense. And I see some hands still. I'm sorry.
Justice Daria.
Thank you, Chief. Yeah, so and maybe this relates somewhat to the relocation, but I guess, I'm very sensitive to the gang issue. I don't know why I feel I have to say that for the record, because I think courts are coming to grips with the fact that can be very inflammatory. But I take the state's point to be, and maybe you can help me come up with a word or a description that, she delayed, including while this gentleman was in prison and her brothers were in prison, because she feared sort of the tentacles of the gang affiliation. So I can't move. I can't, anywhere I go, I'm going to be under threat. She felt that's what she was going to say. And what besides a gang might be a way of suggesting that?
Well, I'm not quite sure I understand. So that the gang evidence still comes in?
I take the relevance to be that the state was perhaps entitled to communicate to the jury if that the delay might have to do with the fact she would delay even while she was in prison. He was in prison because there are people, I don't know how you describe these people, that would be out to get her. And they chose, to use the term gang. He's in a gang. And it's a nationwide gang. I take that to be the proffer, is that it's not just that she's afraid of him. She's afraid of his associates.
Well, I think that's the ultimate implication. I don't think when you read the transcript, she didn't even indicate that was really the problem. It's almost like they injected this new issue here. I mean, yeah, she said, I'm afraid of them. They're a nationwide gang. But again, she testified she was afraid of the family, of the brothers. And I think, you didn't need to even inject this inflammatory issue here, because she did say she felt unsafe when he was in prison. You still had the other brother out there. There was another brother. So the aura here was she's so afraid of Santiago. She tried to leave him several times. And that was really the gist of her testimony in the first place. So, if this was a gang-related crime, I'm not saying this can never come in, but this was not the bulk of why she was afraid here. She could have just said she was afraid of the whole family. I mean, she did testify to that. So it really wasn't something that should have come in. It's not like State versus Cruz that the state refers to, where the defendant threatened the victim, I'm going to kill you because I'm a gang member if you tell anyone. That didn't happen here. I do see another hand still.
Thank you very much, counsel. Justice Kahn, then Justice Keller.
Thank you, Chief. Counsel, my question is similar in many ways to Justice Doria, because I read your argument to say, hey, you didn't need the gang affiliation because she was scared of him and the long history of domestic violence. But there's a difference between, isn't there, a difference between being afraid of one person, because domestic violence is it's very individualized, right? Conduct to one individual. Isn't there a difference between fearing someone for domestic violence in that very interpersonal relationship versus fearing others, whether, and I know you say family, some individuals involved in a group involved in criminal activity may consider themselves family. So isn't there a difference here between, on the one hand, fearing him and the domestic violence, and on the other hand, fearing his family members who she believed were all members of the Latin Kings and their extended affiliation outside of the state? Isn't there a difference there?
Yeah, I can see your point. There is a difference between being afraid of somebody because of the abuse that she suffered, for 12, 16 years. But the other family members that she was afraid of, which she testified she were also involved in this crime. It's not like Santiago was the only one here. You have, if she snitches, you've got to deal with, according to her, my client and Tommy Bonilla. So there are others already out there, when Santiago's in prison, and even when my client's in prison. So I still don't think you need to inject this inflammatory evidence. But even if even if there is marginal probative value here as to why she delayed, you have to balance how this inflammatory evidence versus, the probative effect. And my point is, there's already ample evidence where she says, she's afraid of Santiago.
And I guess that's my question. And I understand that she's afraid of Santiago because she even relays that allegedly the night they come back with the gun, she asks what happened and he beats her up for even asking that question. But I think, it's one thing about fearing someone because you're afraid of domestic violence, which is very individualized and targeted. You don't expect the family member to jump on to the domestic violence bandwagon. Now, I understand your point that the three brothers were involved in this incident, but is it relevant that she comes forward after Vanilla moves out? Other than Vanilla moving in and she testifies to keep an eye on her, would the evidence that they're all involved in a gang that has members inside and outside of the state corroborate her testimony that Vanilla was moved in involuntarily to kind of keep an eye on her, to make sure she doesn't snitch?
Well, I mean, whether or not he's in the gang, I don't know that that specifically goes to him being in a gang. It's just that he's involved in the crime and he's making sure she doesn't snitch as well. Does that answer your question?
Well, I understand your answer. I'm not sure that it can be such a clean-cut separation between the gang affiliation and, on the one hand, and her fear, because not just because she knows about the crime and she can snitch on the crime, but that they're members of an organization that has other members that act a certain way towards snitches. And I guess that's what my question was getting at. But I do appreciate your answer, and I know my colleagues have their hands up, so I'm going to yield to them, unless you want to comment further on that. Thank you, counsel.
No, I'm fine. Thank you.
Thank you, Justice Khan. Thank you, counsel. Justice Keller.
Thank you, Chief. Good morning, Attorney Nagy. The judge gave some fairly decent limiting instructions with respect to this evidence. Wouldn't you agree? And he read them twice. He read them after the evidence was heard, and he read them again in his final instructions. Is that correct?
That is correct.
And he told them that it wasn't to be used for any propensity, that it was to be used to understand why she might have delayed in reporting, correct? Only for that purpose. It was a limited purpose. All right. So, and I'm having trouble with this notion that the state can't anticipate the lack of believability of its chief witness's case and not call in its direct case, put on evidence that would explain what everyone knew here was the main issue, which was her credibility. It was he said, she said, her credibility. And the state also had a letter that Attorney Crozier had given her. It had Crozier testifying. I mean, the state puts on evidence to buttress its witnesses' credibility all the time in cases, in its case in chief. I'm thinking, you see it a lot primarily in the sex assault cases where they call the sex abuse experts to talk about why a child would delay. They don't wait till rebuttal. Those are all put in on the case in chief. Did anybody in this case, did the defendant object on the basis of that's impeachment evidence? It can't be brought out on direct at the time it was brought out by the state?
No, and I do want to make the point that that was not my point. That was not part of my argument. I do want to make that clear.
I just don't think the state should have to present a case where credibility is the main issue with one hand tied behind its back when it puts on its direct case.
Well, that was not my argument, but I will say, as far as the instruction, the reality is you can't unring the bell. Yes, the court gave instructions. Yes, we have case law where, the jury's presumed to follow the court's instructions. When you have inflammatory evidence, which, again, numerous courts throughout the nation recognize this, it's just not something that the jury, it's been planted in their minds. And I think the reality is they can't get that out of their heads. But it was
limited to membership. There wasn't a lot of testimony about what he did as a gang member or murders or drive-by shootings he had committed as a gang member, correct?
That's correct. That's correct.
And you say that, your main issue here is that there was plenty of other evidence to show why she delayed. But in some of your other issues, you argue the opposite, that there wasn't enough evidence to show why she delayed or why she might have made this whole thing up.
I'm sorry, I don't know that I made that point. If I did, perhaps I was not clear. I think there's a lot of evidence here as to why she delayed. So that was my point. If I may turn to the relocation evidence.
If he's in jail, isn't a lot of that evidence undermined, absent the tentacles that Justice Doria talks about?
No, because she testified she still felt unsafe when he was in prison because he did things. She didn't specify, but I think the indication was clear what she meant.
All right, thank you.
Turning to the relocation evidence, the appellate court recognized this as unnecessarily prejudicial, and says though, but because she didn't actually say at state expense or witness protection program, even though it was clear what she meant, that it was, that the prejudicial effect did not outweigh the probative value here. And then the appellate court makes this sort of controversial ruling that even though it's unnecessarily prejudicial, it was probative to show that her testimony about the gang evidence was credible. So, which really doesn't make a whole lot of sense when the gang evidence, again, according to the state, was not a critical part of its case. But more importantly, as Justice McDonald brought up with regard to the other evidence, here the appellate court actually says, well, we don't think this type of evidence should come in before her credibility has been attacked on cross-examination. And again, this came out on direct examination. So I just want to bring that point, and I see I have 5 minutes, but Algarin was obviously the key witness. Her case, without her, the state has no case. And to allow in this type of inflammatory evidence, both types of evidence, when it really did not have a lot of probative value here, and it was cumulative and inflammatory, really was harmful error. The jury did not entirely believe her because they were deadlocked after over 2 days of deliberations on the murder charge, despite her testimony that the defendant told her he killed Morales in part because for retribution for him shooting Santiago years earlier. As far as the relocation evidence, the jury wanted to hear that testimony during deliberations as to when she relocated. And the state was able to capitalize on this and to use this to show the gang evidence plus relocation. I'm sorry, Justice Robinson.
No problem, counsel. Justice Khan has been waiting to ask a question. I'm sorry to interrupt you.
Thank you, Chief.
Justice Khan, you were unmuted. You just muted yourself again. You're unmuted now.
Okay, thank you. It's showing up that I'm muted, but you can hear me, correct?
Correct.
Thank you, counsel.
I got the clock stopped, so we'll.
There's sometimes a long delay between when you press the button and when you actually get unmuted. I apologize. Counsel, I want to follow up on questions that Justice Keller and Justice Doria were asking you. And the issue of, you're saying, look, it's enough that the jury knew she was afraid of Santiago and what he could do to her because of their long history of domestic violence. And then you were asked, well, what about when he's in jail? And your response was, well, she testified he could still do things to her. But those things that he could do to her would have to be through other people, presumably. Would you agree?
Certainly, yes.
And so that's where we get into the tentacles of, if this was a straight domestic violence case and there was no history of any gang affiliation, then she would have to show how from jail he could still have accomplices to do things. And I think that's the part of what I was getting at. If she's saying he could still do things to me, I'm still fearful of him, it means that she's fearful of him, perhaps his family, who are also allegedly gang members of the same gang. Perhaps Mr. Bonilla was a slightly different gang, but that she is afraid of what he can do, the things he can still do because of that gang affiliation. So that's my first question. And then I really was hoping you would get to the issue of the letters and the harmless error, because to me, that is one of the interesting aspects of this case. So I don't want to dwell on this issue. And I also noticed Justice McDonald raised his hand. So the first question of why the tentacles don't matter, and then if you could at some point address the harmless error of the letters not being admitted. Thank you.
Certainly. As far as the tentacles, I mean, she has testified she's afraid. She's testified she's afraid of the family. I don't think you need to put a name on it and say, well, now it is a gang here. She's simply because, and I'm not saying simply because there's domestic abuse. That wasn't what the bulk of what the insinuation was from her testimony, that he's still doing things while he's in prison. You know, obviously he can't abuse her then, but there already was this aura of there's violence in the family, there's threats. You know, one of the family members who's not in prison, who's involved in the crime, is still there. So that's really the best I can do as far as answering that. May I answer the question about the letters? So the letters, you know, what the appellate court ignored here is that this was not just impeachment evidence. It was evidence that went to her motive for fabricating this entire story. And the defendant wanted to show, this was the only way he could show that his theory was once Santiago saw these letters, he became so enraged that he ended their 16-year relationship. And without the jury seeing and knowing the content of the letters, you know, the standardized questions, oh, did you write sexually explicit letters? That's not enough. And I'm sure this court has looked at the letters. There's a lot of nuances here. And the reason why it's harmful, you know, the appellate court found it was an abuse of discretion. It's harmful here. And I liken this case to State versus Colton, which Justice Ecker, I know you were involved in that case. But, you know, this is the key witness, and the defendant is allowed to put on evidence as of her motive and bias. And, you know, here she's, you know, denies, well, you know, I didn't, I see my time is up.
Counsel, please finishing answering that question. Then Justice McDonald has a question. I will compensate and give the state a few more minutes on this argument too.
Thank you. You know, as in Colton, that was the main witness there. And even though there was a lot of cross-examination trying to impeach her, the fact that she kept denying that she had changed her life and that was why she finally came forward. She denied she was a drug addict and involved in prostitution. And it was wrong and harmful error for the court not to allow evidence which contradicted that to come in. And that's what we have here. She says, no, he didn't break up with me. I broke up with him because of this, you know, faking a stroke in prison. But defendant should have been able to put in these letters so that the jury could truly understand why he would become so enraged and break up with her. You know, that was his theory. That went to her motive, that went to bias, and the appellate court just overlooked that and said, oh, there was ample evidence, you know, that he was able to cross-examine her and impeach her testimony. And you know, the point is here is that it also went to motive, it went to bias. And there was no other evidence here which he had to show that she had a motive.
Thank you very much, counsel. Justice Conner, you through? Thank you. Justice McDonald?
Thanks, Chief. So, counsel, on the letters, I guess I was confused about the court's ruling, and I don't know if it was clarified or at some point, but the court said that it was that its probative value was outweighed by its prejudicial effect. Prejudice to whom?
Well, that's a good question. I took it to mean that it was prejudice to the state. But you know, the court didn't make that clear, but that was my understanding because clearly defendant wanted them in. I don't see how those would prejudice him.
Okay, and so we're not talking about it being prejudicial to the credibility of the witness, are we?
No, I mean, the way I read that was he was saying that it's going to, the jury's going to look at her in a bad light. That's how I took it.
Well, and does that, so if that's correct, how does that tie into what we said in State versus Brown, that that a cross-examination can't be unduly restricted and it is a matter of right. Is that that's your argument, that given the fact that credibility was at this juncture in play, that you had an opportunity for a robust cross-examination, including not sanitizing the contents of the letter?
That is part of my argument. Yes. I mean, the whole case here revolves around her credibility, but also because, I don't see how this could prejudice the state, but, she's the key witness. And on top of that, cross-examination as to motive and bias is not something that the court should let out. That is almost an absolute. The defendant has the right to show that. And our cases all say that. And here, so it was not just that he was prevented from cross-examining her to impeach her and to impeach her credibility, although it went to that, it also went to her motive and why, the claim here was that she was motivated to make up this story to get revenge at defendant, to get revenge at Santiago.
Okay,
And
I have not read the transcript in the detail that you have. Will that be borne out that it was being offered for both the motive and the credibility?
absolutely.
Thank you.
Thank you very much, counsel. I'm going to add 4 minutes on the state's time. You have the remaining of your time for your rebuttal, counsel.
Thank you.
Mr. Costello, you ready to proceed?
Yes, I am.
Thank
Good morning,
you. You have 34 minutes.
Thank you. Good morning. May it please the court. I'm Timothy Costello, Senior Assistant State's Attorney, appearing on behalf of the state in this matter. The trial court here did not abuse its discretion in any of its evidentiary rulings, either excluding or including the testimony challenged by the defendant. First, to begin with the gang evidence. In this case, and directly responding to Justice McDonald's earlier question to my opponent, the trial court knew, because it had presided at an earlier trial, how the impeachment of Algarin was likely to proceed. Therefore, it properly could admit testimony that related to her credibility and, in fact, bolstered her credibility. To that end, it properly admitted testimony that the brothers were members of gangs that had violent tendencies. The testimony was not admitted to establish a criminal propensity. Instead, it was admitted to establish that they could threaten and harm the Algarin in this case.
Mr. Costello, there's a question from Justice Daria, then Justice McDonald, then Justice Acker.
Okay. Yeah, Mr. Costello, good morning. Is there another way to get that across to the jury? I mean, the word gang seems to be the case law recognizes inflammatory. We know that its impact on the jury can mean, these are dangerous people. What do you think of that? This has to come up with some regularity.
It does. I mean, the circumstance in which it usually comes up is when it's admitted for motive in a case where the evidence relates to a crime being committed, say, in retaliation from one gang to another against another.
Yeah, I mean, I guess I should take that back. Maybe it doesn't come up with regularity as it relates to a witness's own motivations or a delay in this case. But I mean, I think we need to do better. Unless we can't do better, can we not do better than the word gang? Would that be the state's point?
Well, as I brainstorm on my feet, maybe a court could suggest just stating that the brothers were part of a network or part of a group of associates. But I think those terms would be unduly soluble, because what does that mean? What would a jury do with those words? Does that mean co-workers? Does that mean the garden club? It becomes very unclear. The fact that it is a gang has some relevant meaning. Gangs generally are engaged in criminal activity, organized gangs anyway, and that they can engage in violence to protect themselves. I think in that sense, the word gang is relevant and duly probative in this case, because it is the very fact that the witness in this case had been threatened and that she still feared for her life, even after the brothers were in prison. That was relevant in this case.
Can I ask you, was she the first
1 second,
witness?
Justice Daria.
Oh,
1 second, please. There's a lot of microphones that are not muted, and it's a problem. I'm getting feedback. That's better. Thank you.
I mean, was she the first witness?
She was not the absolute first witness. There were witnesses who testified to Morales' activity on the night of the murder and the discovery of his body. Those witnesses testified first.
So, but I guess I'm wondering in weighing the prejudice and probative value, then maybe it does go to the fact that the state puts it in on direct, because it's the main witnesses. You know, this is the first thing they hear about her, is that she is fearful of a gang. I'll just let you respond to that. Others have questions.
Well, I think the sequence in which the evidence comes out can inform a trial court's exercise of discretion in balancing the probative versus prejudicial value. The circumstance maybe where it presents itself most commonly is in, say, child sex assault cases, where efforts to bolster the victim's credibility should not be admitted until the witness has been impeached. That is because the strategy that is likely to be implemented against that witness may not be apparent at that phase of the trial. This case is a little bit unique. As I note in footnote 2 of my brief, the same trial court who presided at the defendant's trial had previously presided at the trial of one of his brothers, at which Algren had also testified. And this is hashed out in some of the pretrial hearings. The court knew that Algren had delayed in disclosing for 12 years, and that her credibility would be heavily impeached in a myriad of ways. Even at those hearings also, the defendant's counsel below referred to her as a liar. He was characterizing her that way early on. And when the court suggested that her credibility was going to be attacked and a central issue in the case, the defendant's counsel did not dissuade the court of that opinion. So in this case, this really follows in line with what this court said in Saucier. A trial court, in exercising its discretion, can permit the state to present testimony or evidence preemptively to deal with an attack that is clearly going to occur in the case. I think this case clearly falls within that circumstance, at least based on the particular facts that the trial court knew how the strategy was likely to proceed. It might be different if it was a much more opaque strategy that was going to be occurring going forward, but that was not this case.
Thank you very much. Justice McDonald?
Thanks, Chief. Well, counsel, I mean, that I'll take your word for the record. It's still, just because it happened in a prior case, how it's going to unfold in another case, presumably not the same defense attorney. Maybe I'm just too formalistic, but why isn't it right to wait your turn? I mean, it's not relevant in a strictest sense of proving the crime, right? It's not relevant for that purpose. And so it is still this defendant's strategic decision about how to bring up her credibility. I mean, could you bring out that she, I don't know, that, you know, in addition to being afraid of gangs, that she goes to church every day? I mean, it seems weird to anticipate it. And I think the sex assault cases are different because that's based on a whole set of social science that has been built up over a long period of time. So I'm just trying to figure out, why isn't it right? It may not be harmful to your case, but why isn't it right as a matter of form to wait for redirect?
Well, it is not required as a matter of form simply because the court's precedents, first and foremost, don't require it. But it may be the preferable procedure in many cases. I argue this case, though, is a bit different because there is no manifest strategy that is going to be implemented other than to impeach this victim's testimony. This is a bit of a singular case because this witness had testified numerous times previously in other proceedings, and the court was cognizant of that. The fact that the court knew that in this case was placed on the record, and is certainly part of the court's discretion in balancing the testimony.
And thank you, I appreciate that. Your answer, I'm sorry, washed over me too quickly. What was the case that you referenced, Saucier?
State versus Saucier.
And what did you cite that case for the proposition for?
It is for the proposition that a court may admit testimony that the relevance and the probative value of the testimony may be apparent even before a witness has been impeached. It can be admitted for the purpose of to rebut impeachment that is going to occur or is likely to occur.
Okay, I don't see that cited in your brief. Is it in your? All I saw was a cite to State versus Cruz, an appellate court case that held that proposition. And what I was going to ask you, maybe you just answered it, is if we've ever endorsed that. So maybe that's saucier, but did you cite it?
That's the court's.
It's not in the table of conduct, table of authorities.
Sure, it's not. I may be mentioning the wrong case. I'm sorry, it's State versus Beavers that I have in mind. I mentioned Saucier by accident. There's a footnote in Beavers that says that.
Thank you.
Sorry.
That's all for me. Thank you. That's all for me. I have some questions on the other ones, but it sounds like we're all focused on the gang part right now.
Sure.
Thank you, Justice McDonald. Justice Acker.
I may open things up a little bit because I had a question on the other on other issues too, and I don't know when Mr. Costello will get to them otherwise. But on the gang issue, my question is whether there was any evidence of a trial of any threats by gang members, or that one of the brothers said my gang will get you, or anything like that.
There isn't an explicit statement like that. There certainly is testimony of threats from Santiago himself and the brothers.
Right, but why? So doesn't that go into the balancing test? I mean, I guess we're assuming that everyone knows that Latin kings will retaliate and seek retribution against witnesses. Is that common knowledge? Is that something we learned on X-Files? Where did we learn that?
I think the relevant point that it comes in with for is the fact that the Latin Kings are a nationwide network. That is the testimony that came into evidence, and it is relevant to establish that maybe they sell pizzas and burritos and hamburgers. I don't know, but so we're assuming an awful lot, aren't we, by those words? Now maybe we should. Maybe it's quote common sense, but I just wanted to establish. I mean, if there was some record here of actual threats, of actual, my people will get you, that may be different. It sounds like there weren't. On relocation, let me ask you this. It sounds like the judge did some balancing on gangs. Now, whether we agree with it or not, whether, is a different issue. But on relocation, as I read the record, the judge just said, I don't see the prejudice. Now, if the judge was wrong about that is that there, to me anyway, I'll just speaking out loud, thinking out, the prejudice seems palpable. Now, whether the relevance is greater than the prejudice is a different question, but the fact that the state has credited and stands behind those witnesses' claims of fear and is vouching for it and has actually expended taxpayer money on it, that seems very, very prejudicial. Whether it's undue or not is another thing. And Judge Murphy never even considered that, did he? I believe he did to an extent. Judge Murphy believed actually that the defense might elicit testimony that the witness had been relocated at state expense. He did consider that. The defendant ultimately didn't bring out that testimony. But
he didn't consider the prejudice in the way I'm speaking of it, did he? In fact, I think he said affirmatively, I don't see the prejudice. So my question is, how could he? Isn't that an abuse of discretion?
No, I don't believe it's an abuse of discretion. Judge Murphy considered the relocation evidence as revelatory of the hardship that the witness had endured, that she had to uproot herself from Waterbury and relocate out of the state.
That's the relevance, but what's the prejudice? What about prejudice? Did he consider that?
He did consider that, I believe, but the fact that he sanitized it to some degree cut down on the potential prejudice. that might arise. I understand.
Where did he consider the prejudice? Can you point me to a place in the record? That's maybe an unfair question because it's a huge record, but did you have anything in mind?
Well, the court considered the prejudice by finding that relocation in and of itself, and witness protection in and of itself, because it had an official sound, could be prejudicial. But reference to witness protection itself did not come out at trial. It is only evidence that she had relocated. So
Well, she was in relocation.
Yes.
Let me ask you my final question, and then I'll let others ask you. You know, we talked about cumulative effect. No, we didn't. You know, opposing counsel said she's not going to raise that. I know there's law on it, but you know, sometimes the sum is greater than its the whole is greater than the sum of its parts. You know, in some math equations, it's not. But anytime you tell a story, it is, and especially in evidentiary rulings. So what concerns me here is, you know, anything goes as far as, not anything goes, but the state got in its evidence. The state got in the gang stuff. The state got in the relocation stuff. Fear, fear, fear. Then when he tries to put in, you know, his salacious letters, that doesn't get in. So I'm concerned about that. You know, and I guess, you know, isn't that something that should be considered? The cumulative picture?
It should not. The cumulative picture should not necessarily be considered, because at the time that the trial court,
when what we're talking about is stories and narratives that have their carry force only because of their cumulative effect.
it may speak to a question of harm. It does not speak to the court's exercise of discretion, however. The court exercises its discretion at discrete moments in time based upon the record and the facts and its knowledge at that moment. And its exercise of discretion, whether it's abuse or not an abuse, has to be determined based upon what was before the court, not on what the court subsequently came to know, unless a claim has been preserved.
Fair point. Okay, thank you very much, sir.
I see there are questions.
Sorry, counsel. Justice Keller, then Justice Kahn.
Chief Attorney Costello, I'm bothered by the lack of the failure to admit those letters. You know, I read them, and I find it really hard to believe on the basis of their content that she copied any of those letters off of a website, because they're just not written that way. Okay, they're far more personal. Wouldn't you agree that the real reason the court did it was to protect her from embarrassment?
I think that the court could exercise its discretion and find that they were unduly prejudicial on the basis that the letters would, the most salacious wording of the letters could distract the jury because they were titillating, because they were vulgar, because they were almost absurdist.
Isn't that a somewhat prudish approach for a criminal trial court judge to be taking? Especially today.
I'm not certain that I can speak to whether or not it's prudish. I can speak to whether or not it was an abuse of discretion.
I mean, he told him he could only ask her, he could never describe the sexual acts she describes in those letters, correct? He would not let her do that.
Not using the specific verbiage of the letters.
All right.
It did permit.
Did he let him ask her about all her professions of love toward the defendant?
Yes, the court's ruling expressly would have permitted inquiry into whether or not they were graphic and affectionate letters.
And did he ask those questions?
The defense counsel exercised some forbearance for reasons that I cannot understand into the scope of questioning that he was permitted regarding the letters. So he did ask whether or not there were letters, whether or not they were affectionate, but did not get into any subsequent detail.
Well, that could have been strategic. Yeah. All right, thank you.
Thank you, Justice. Thank you, counsel. Next, Justice Kahn.
Excuse me, Stella. You need to mute when people are talking. Thank you. Sorry, Judge.
Okay. Can you hear me? Can you hear me, counsel? Okay. I know I'm unmuted, but I just wanted to make sure I was hearing an echo. So I want to ask you about both issues, but I'm really more concerned about the letters, as I said to your opponent. To me, that's the interesting issue in this case. Not that they're not all interesting, but I'm really concerned about the trial court not letting in those letters. And so I want to ask you a question about that. But before we turn to that, both in your brief and in the appellate court's decision, the appellate court, in its recitation of facts, indicates that Miss Algarin testified that when Santiago came home with his brothers after the alleged crime occurred, that she came downstairs, she saw bags filled with, she saw the money in the blue bag, and that they were cleaning the gun. And it states, when she refused to go with him, meaning Santiago, to dispose of the bags filled with the gun parts, Santiago continued to beat Algarin. He beat her because she asked what happened, beat Algarin until the defendant intervened. So in this case, he's beating her, domestic violence, and the defendant, Bermudez, intervened. Reluctantly, she agreed and accompanied Santiago to dispose of the bags. When the third bag was thrown in the Naugatuck River, Santiago again threatened to kill Algarin, her mother, and their children, stating that now you know what we're capable of. Not what I'm capable of, what we're capable of. So isn't that some evidence that, you know, he's involved in a group that will kill, basically, if anyone snitches on them?
Yes, it is. And I had started to get that response out in response to Justice Ecker's earlier question. The threats did begin on the night of the murder when Algarin came downstairs and continued thereafter. In her testimony, she testified that she was afraid of the brothers because of the threats and of what they had done in the past. So I mean, it was a collective knowledge on her part as to the violence they had committed directly on her, and presumably outside of that, that informed whether or not she still continued to face threat even after the defendant and Santiago were imprisoned, beginning around 2008.
Now, I want to get to a different aspect of the appellate court's decision and to that second issue. And I know that in the appellate court's decision, the appellate court drops a footnote at A65 where it says, hey, the trial judge here allowed the defense to question, cross-examine Miss Algarin about specifically the content of the letter. And this is a follow-up to Justice Keller's question, and this is my concern with the court's ruling. The court seems to suggest, look, I'm going to let you quote from the letter. You just can't quote, you know, the slang words or salacious words for the conduct. You can use sort of generic terms. You can, I'm assuming, I guess I shouldn't assume, you could use the word fellatio, but you can't describe what the words she used to describe that. And I'm troubled by the fact, why not let the letters in? Let the jury see, because when you read the letters firsthand, you get a sense of, is her explanation that she took this off of Google? I mean, one of the letters goes on and on and on, you know, tiny print. It does seem rather incredulous that she would have gotten the detail or the language, or that someone who's a wife, a mother, you know, of a certain age would not know salacious sexual conduct. So it seems like the court, you know, when you weigh prejudice against probative value, this seems highly probative. It goes to the heart of the defense's case, that this woman is not scared of them and she's making this up. Why wouldn't the court just let that in? And why was it not harmless, given the nuance in the letters?
Well, I believe that a court in its discretion could admit the letters, but in its discretion also could decline to admit the letters. The fact that there were such almost ridiculously salacious comments and phrases in the letters, a court could find could be unduly distracting to a jury, because the human mind has a tendency maybe to focus myopically on things that are titillating or almost comically sexual, or sexually comic, perhaps the phrase should be. It also could portray some of the ridiculousness in there, could portray the witness in an embarrassing light beyond what the proffer had been. The defendant wanted to establish that after she had witnessed the murders and allegedly been threatened and was fearful of the defendant and his brothers, she remained affectionate toward them. It was the fact that she remained affectionate toward them that was proffered to the trial court as being relevant to her credibility and undermining her statement that she maintained a false alibi and did not come forward for 12 years. So the fact that the letters existed and that they were of a sexual and affectionate nature was the claim, because that is what was contradictory to her claim of fear. The specific wording itself was never actually claimed below as being directly relevant to that point that the defendant wanted to establish. And I don't even, yes.
But isn't that part and parcel of what did she intend to do? And did she send these letters for the reason she claims, which was so that Bermudez could have insurance, if you will, that she wouldn't testify against him in the future? Or did she send them for some other reason? And shouldn't the jury have seen those letters firsthand to assess that? I guess that's what I'm troubled. Now, it may be that counsel should have probed that further and tested that further. And maybe as criminal litigation goes, that who knows where that would go. But it seems to me that the tone, the tenor, the language that she uses is part and parcel of why she sent the letters. And so I'm struggling why that, I know the appellate court found that it was error, but that it was harmless. I'm struggling with the harmless aspect of it when she's such a central witness and the letters contain such, detail about her. The whole case is about what she feared, didn't fear, what she was feeling. So why wouldn't the letters be so key? And I'll end there because my colleagues have their hands up as well.
Well, I'll just address harmlessness directly. I think that's what your question was primarily getting at. And the position as to harmlessness is that the letters that were not outright excluded from the jury's consideration. The jury learned through Algren's testimony that the letters existed, and the court's ruling would have permitted the defendant to establish at length the nature of the letters and their content. All that was really kept out was specific vulgarities contained within that letter. The defendant never claimed that the handwriting or how it appeared on the page, he never claimed below that was relevant to the jury's consideration. It was really the content and the existence of the letters generally that the defendant was relying on. Here, the defendant could have gotten that out based upon the trial court's ruling, even if it was error to omit or to prevent admission of the physical exhibits themselves. The jury heard their substantive comment with just some sanitization as to the wording used. The jury heard all of that and heard Algren's explanation for it. The fact that she had written sexually graphic letters to the jury was before them. I would also note that the jury had as full exhibits 3 letters that Algren had written to Santiago while he was imprisoned that also were affectionate in nature and therefore would have doubly rebutted any claim that she remained fearful of the defendant and his brothers during their time of imprisonment. So the fact that the defendant hasn't really claimed or argued that any particular words in the letter in their most vulgar form was directly relevant to Algren's credibility, I think signifies that those vulgarities themselves, outside of the general substance of the letters, what was necessary to go before the jury to aid the defendant. I see a question from Justice McDonald.
Thank you, counsel. Justice McDonald.
Thank you. Well, based on all of that, I have a couple of new questions that I didn't have previously. First of all, to take up the letters first, it's rough justice to say that they were affectionate and romantic. They were salacious and lurid, and that's a very big distinction. But the trial court didn't even allow the defendant to enter the redacted letter. I mean, the court was very clear. Letters, even in redacted antiseptic form, weren't getting before the jury. How is that not How is that not harmful to the defendant? And don't repeat your answer from Justice Kahn. I'm talking about the redacted letter.
Well, if the question is harm, I would still have to incorporate by reference my response to Justice Kahn. The fact that it wouldn't allow in the redacted letter, I think must be taken in light of its earlier permissive ruling to the defendant, that he could inquire almost line by line as to the substance of the letters. I don't know exactly why the court didn't want to admit the redacted letter. It didn't specify whether or not it was because it became too unclear.
Well, he wasn't going to hear it. I mean, he was hearing none of it.
Well, the court wasn't hearing the specific wording, is my response. It wasn't that the substance of the letters was too distasteful for the court. The court was going to permit inquiry into that they were lurid, that they were salacious, that they were of a graphic sexual nature. The court was going to permit that inquiry. It is just specific words that the court did not want to go before the jury. I think whether or not the court admitted these specific words or not does not change the ultimate point for which the defendant wanted to admit the letters, which was to impeach Algren's statement that she remained fearful during the period after the murders.
And I want to be clear, it's the state's position that the graphic nature of the letters of what she wanted to do with the defendant wouldn't undermine her credibility that she was fearful of this defendant. Is that the state's position?
Not exactly. It's the state's position that the court would have admitted testimony that she wanted to do sexually graphic things with the defendant. It is just specific and vulgar wording regarding those acts that the court did not admit. So the fact that she had expressed a desire or a dream, fetish about what she wanted to do with this defendant was permitted by the court's ruling and could have gone before the jury.
Well, we had an analogy in our last case to coloring books. I won't do that, but hearing about a Monet water lily is very different than seeing a Monet water lily. Would you not agree?
I would agree. Perhaps anticipating your follow-up question here, though, I believe the record below is bereft of any claim that the physical appearance of the letters was relevant to the defendant's claim. I believe the court below perceived the claim to be that it was the substantive content of the letters rather than their appearance that was relevant, and that the court tried to let in the substantive content in a discretionary way that would have sanitized the jury from hearing these most vulgar words.
Okay, and my next question is, you seem to argue, or you quote language, I shouldn't say, you quote language that the court was actually considering this to be prejudicial to the witness, not to the state. Is that right?
I think a claim that a statement that it was prejudicial to the witness is one and the same to a degree as it being prejudicial to the state. The undue.
So help me with that. What authority is there that you can offer me that devastating cross-examination material is prejudicial and therefore shouldn't be admitted? What authority do we have to say that?
Well, the response to that, I think, is the court can determine what is duly prejudicial and unduly prejudicial. Wording that is merely has titillating effect or might cause the jurors to giggle for no reason itself could be unduly prejudicial in that way because it could be distracting. The fact that it is duly prejudicial to the extent that it contradicts the witness's prior testimony that she was fearful that the jury could make that finding. But that content got in. What was kept out was limited wording that I think could be distracting to the jury, could portray the witness in a comical light, independent of the jury's evaluation of her credibility.
So I didn't do exhaustive research into this, but the only case law I found on this issue of prejudice is that it has to be prejudicial to a party. I found nothing that said that it's prejudicial to a witness is a basis to exclude it. Do you have any such authority?
I don't have authority saying that the court has, say, an obligation to protect a witness's dignity or something to that effect. But I would sort of reiterate what I said a moment ago, that prejudice to a witness that is undue prejudice to a witness can be prejudicial to the party that is offering that witness. If it is just evidence that may lure the jury into considering tangential issues or wholly unrelated issues, the court can deem that to be unduly prejudicial. If the jury is going to be in the jury room giggling and going over the letters line by line, not to determine the witness's credibility, but to laugh amongst themselves like some sort of locker room humor, that would be undue prejudice. The due prejudice in this case was the fact that the letters contradicted Algren's testimony that she was fearful. They were.
Okay. Nobody else seems to have their hand up, so I'll just ask one final question. And in pivoting to the relocation question, the appellate court said, quote, that the relocation of the witness information, quote, is relevant to a central issue in the case. What was the central issue in the case that her relocation was relevant to?
The central issue in the case was Algren's credibility. That harkens back to the court's prior statement that it was aware that Algren was going to be heavily impeached and at length impeached in multiple different ways. The court understood that the fact that she had to relocate outside of Waterbury after coming forward was a significant hardship on her. It was even doubly damaging, harmful to her because she also feared for her life and the life of her family. Taken together, the court rightly found that that was probative and not unduly prejudicial in this case.
It almost sounds like the state is bolstering her by relocating her, that it's bolstering her credibility. Is that wrong?
I disagree with at least one point on that. As I've said in my brief, the testimony that came out did not establish that the state had relocated Algren, and I would just argue, full stop there, that the evidence that the state relocated her did not go before the jury. So that is not in the case. In any event, though, I do argue in my brief that even if evidence that the state had relocated her had come out, that would be properly admitted in this case. Where we have established the predicate threats by the defendant, where we have established the gang affiliation, the fact that she has gone into witness relocation and has had to relocate out of state is highly probative of the fact that, as to her credibility, because it demonstrates an extreme hardship on her that directly resulted from her coming forward.
Thank you, counsel.
I'm not sure if Justice Mullins had a question. I saw a hand up earlier, but he's no longer on my screen.
I just wanted to let you know, Mr. Costello, I failed to put up the 5-minute mark, but so you're just under 3, if you bear with me on that. Maybe closer to 2.
Thank you. Justice Mullins, do you have a question?
Not generally. I think the ground has been tilled quite a bit on harmless. My concern was the harm or harmlessness of the letters. I think what I was going to ask you, though, was we often get the argument from the state where the state puts in some evidence and then some other evidence sort of goes to the same point, and the defendant is like, hey, we already have evidence on this. The state shouldn't be able to do that. And the state's response is often, we have the burden of proof. We have to put in the case the way we see fit. So, and the court has been receptive to that argument. And I'm just wondering why that wouldn't work on the other side. Maybe the letters do go and they get a little salacious, but it's her letter. She wrote it. They're evaluating her credibility. And so why wouldn't it be an effective argument for the defendant to simply say, hey, this letter should come in as it is, as she wrote it, so the jury can evaluate that letter. And so what, that the primary reason is to get the affection she still had for them out. They can prove their case however they want, as long as it's relevant. Why wouldn't that be effective for the defendant in this case?
I think it could be effective for the defendant in this case, and I reiterate my earlier statement that the trial court, I believe, recognized that fact and therefore allowed a very permissive inquiry into the letters, just not the physical exhibits themselves. So I think that the trial court recognized that it was appropriate to inquire in this area, just didn't want it to go on for too long. So it may be, to an extent, either that it would be distracting to the jury or that delving into the letters at length might be somewhat cumulative to what the court permitted to come in. I would argue, however, though, that to the extent that some evidence was admitted for the state and maybe not admitted for the defense, at least does harken back to the centrality of the witness's credibility in the case, as well as the allocation of the burden in the case. Both sides certainly should be able to put on solid and good evidence, but the state bearing such a weighty burden in a criminal trial should get a slight edge, perhaps, in those rulings in many cases.
But why so? Because the defendant is going to bear the burden of going to prison for quite some time. So, you know, if there's evidence that's relevant that is on the line and should come in, why would the balance necessarily tip toward the state? I mean, he's going to have to do the time. That's pretty significant.
I think it just speaks to the fact that in these cases, either side should be unduly restricted in its presentation of evidence. But of course, how much has come in and whether or not any prolonged or microscopic examination of tangential points is appropriate. Maybe I would go back just more broadly and apply it to this case. The trial court did admit the testimony regarding the letters, just not the letters themselves, and therefore it did not unduly restrict examination into this area. It did not bar examination into this area. The jury did know that the letters existed and could have learned of their substantive content. I believe I'm out of time. If I'm not, I am out of time, so I would simply ask the court to affirm the judgment of the appellate court.
Thank you very much, counsel. Attorney Nega, I want to add another couple of minutes to your time, so you have about 7 minutes.
Thank you. I do want to address the letters and the state's argument. I disagree wholeheartedly that a defense counsel was allowed to get into the substance of the letters. And I point this court to, and I think I thought I made it clear in my reply brief. He could not even mention fellatio, as Justice Kahn said. He could not mention any of that. And on page A159 kind of sums it up, but the court says it several times. It's at the very bottom. I think you are allowed to probe, didn't you write these very affectionate, graphically sexual letters? But I don't think there's a need to go into any other detail. And, you know, earlier on in this argument or this court's ruling says, you know, you can't get into the exact language. And he says, and what the state, I think, is trying to sort of twist it. What he said to defense counsel was, can't you say to her, don't you go line by line and indicate things that you want to do to the defendant? And the state's twisting that to say that the court was saying, defense counsel, you can go line by line and ask her. And that is not how I read the court's ruling. I think it's very clear. But so for the state to say now it's harmless because he was given this wide latitude to cross-examine her, that's not correct. It's not correct. And it's not the same thing as saying, oh, you know, you wrote some graphic letters. Well, now the jury knows that. No, they don't know the tone of the letters. They don't know the nuances. They don't know any of that, which went to her credibility as to why she wrote the letters and her fear of Mr. Bermudez, but it also went to her motive. The jury could not understand why Santiago would become so enraged. Especially because when you read the letters, I think there's a fair reason why he would become so enraged. And I do want to point out with regard to Justice McDonald's earlier question on pages A32 of the appendix, which was the motion for a new trial, and on page A154 of the appendix, which was the defendant's argument as to the letters, he does indicate they also went to her motive. So I just wanted to point that out. As far as the relocation evidence, this also goes to one of the questions here. On page A103 of the appendix, the judge specifically says he does not consider the relocation evidence to be prejudicial. That's around lines 5 to 7. So the judge did abuse its discretion, did not consider it to be prejudicial, and it's something the appellate court did not even consider, that the trial court didn't consider it to be prejudicial. On top of that, part of my argument is that this does bolster her testimony. It's giving the stamp of approval by the state. Not only is she, bolstering her testimony about the gang evidence before she's ever been impeached, not only is it problematic because of the connotations now that, that the defendant and his brothers are so dangerous, she has to move out of state, but it puts a stamp of approval and that the state also believes that to be so. I think there are some questions.
Yes, Counsel, you have about 4 minutes now. I just lost track of who it is. It'll be Justice Kahn, then Justice Doria, then Justice Keller.
Thank you, Chief. Counsel, my question is, when it comes to the letters, isn't part of your point, and this goes to Justice Mullen's question to your opponent, the state often introduces salacious material and makes the argument that it's part and parcel of what the jury needs to consider. And so isn't it really here, it's the very salacious nature in detail of the letters that the jury needed to see firsthand in order to assess her credibility and her explanation as to why she wrote these letters and whether in fact she was fearful or not. It seems to me it kind of goes, it can cut both ways, right? On the one hand, she could have said, well, I did it because that's what he asked and I wanted to make it credible. I suppose that could be the state's argument. But to just say, no, you don't get them in because they're salacious, well, that's not the standard. And I know that the appellate court found error, but it's the very salacious nature of them in detail that goes to whether they're harmless or not. Isn't that your argument, really?
No, absolutely. That is my argument. You know, it's something the jury needed to see. It was for the jury to determine whether or not her excuse, which she claims she wrote them because defendant made her write them, and you know she went to this website. It was for the jury to determine whether or not that was credible, and they can't do that by simply this arbitrary ruling that the court makes. Well, you can just ask, you know, were there sexually explicit letters that you wrote? That doesn't do it. And, you know, it's true. The state often puts in a ton of evidence, you know, things like that. But yet here the court doesn't let defendant do it at all. And again, this is all central to her credibility.
Thank you, counsel.
Counsel, you have 2 minutes left, and it's Justice Doria, then Justice Keller.
Could you speak briefly, Attorney Nagy, about the Crozier letter? Could you tell me how that came in and how he was crossed and why, I guess, I'm sorry, it's 3 questions, why that doesn't, I mean, she told this story before and why that might not really bolster a harmless argument.
Are you referring to the Waterbury Hospital incident?
I shouldn't say the letter. I'm sorry. His testimony, right? He testified that she told me this story before, close in time to the incident. Yeah, sorry.
Correct. Well, maybe I misunderstood the question.
Doesn't it go to? I mean, it really bolsters the harmlessness argument that, and I guess I wonder, how was he crossed on that? Was that impeached in any way?
Well, I think he tried to impeach Crozier's just the fact that he had all these convictions, that he was, you know, that he wasn't a very reliable witness. Okay. What I will say here, as far as the harmlessness or harmfulness, Crozier, you know, again, his testimony was impeached just through his credibility was impeached. But on top of that, Crozier was a childhood friend. And there's no indication, even if the jury found him to be credible, it all came from her. You know, it's still, you know, her word. This is what she's telling. She's telling this story to someone. You know, it's not like there was some it really doesn't corroborate anything. It doesn't say, well, oh, well, here's the body and now we found the body. It doesn't do that. And the other person she told, Sally Timko, doesn't even remember this. You know, yes, there was a police statement that came in. She said, you know, she wanted to get out of that situation. She was, you know, like terribly embarrassed and intimidated by the police. So her testimony doesn't really, you know, make it harmful. You know, and again, it's something that Algarin told her. So I don't think, you know, again, we're on Algarin. It's her word.
Okay, thank you.
Justice Keller.
Thank you. I had a quick question. The relocation, I know that they didn't hear that it was the state that relocated her, but didn't they hear that she also got a reward for coming forward? like thousands of dollars, right?
I think it was like $28,000.
Why couldn't that evidence work both ways? It could be prejudicial, but I could see why the court felt, well, this is something she got, and it's a nice thing to be able to get money and to be able to start a new life somewhere else. So wouldn't that have also an effect to doubt her credibility, because what she's really looking for is reward money and the possibility to get out of, what town is it, Waterbury, and go live afar with her new boyfriend?
Well, sure, the jury could try.
I'm just trying to think, that might be why the trial court didn't think it was so prejudicial. It's like anything else they promise a witness who testifies.
Well, I think the court's thinking was that, well, it can go both ways, therefore it's not going to prejudice you. But I don't think that, I don't believe that to be so here, because they're hearing now her fear. Now she has to be relocated. These guys are so dangerous. Now the state believes that, she has to be relocated. And the clear implication here is, relocated. She was in relocation. The clear implication is that was done by the government. And if you look at the letter that the jury, or the question, the note, it's the very end of the appendix. They didn't say, when did she move? They want to hear testimony when she was relocated. It was very clear. It was very prejudicial.
All right, thank you.
Thank you. If there are no further questions, I will rely on my brief for the last issue with my arguments with regard to that issue. And I would ask that this court reverse the appellate court decision and award Mr. Bermudez a new trial. Thank you.
Thank you very much, counsel. Sorry about it, the way the timing worked, but it was sort of a hot bench, and I wanted to make sure you both had all the time that you needed to get your arguments out. And I thank you for your patience. With that, we are in recess until tomorrow morning. Thank you, everyone. I'll see the justices in the virtual courtroom, let's say at 1 o'clock.